Chapter 4. Elections. It is by means of elections that their will of the electors, in the choice of officers to manage the affairs of the district, is expressed. These elections are governed by constitutional and statutory enactments. The numerous litigated cases respecting elections have given rise to a common law upon the subject, part of which is borrowed from the common law of England. The succeeding pages of this chapter are designed to point out, very briefly, the general principles governing such questions as are most likely to arise upon school elections. 1. Time and place. Time and place are of the substance of every election, and the election must be held at the time and place established by law. Where a notice of an election for a school district specifies several purposes in such a way as that no doubt is left as to its meaning, it will be sufficient, although there may be an omission in it of a copulative conjunction. Where a statute requires polls to be kept open from 9 o'clock a.m. to 4 o'clock p.m., an election called for 1 o'clock p.m. is void. A meeting of the electors of a sub-district for choice of a sub-director convened at 20 minutes before 4 o'clock and adjourned at 10 minutes past 4, shortly afterward, and while the president and secretary were still in their places, and all who composed the meeting were present, 2 qualified electors came in and tendered their votes. Held, that they should have been received and counted his work on constitutional imitations, to both of which the reader is referred for a complete treatment of the entire law of election. Although the law directs that the polls shall be closed at a designated hour, and this question is at issue, unless it be made to appear that votes were cast after that hour which change the result, the irregularity will not be fatal. So, 2. Votes should not be rejected merely because the judges closed the polls an hour before the time prescribed, if there is no evidence that any voter offered to vote after the polls were closed, or was prevented from voting by reason of such closing of the polls. 2. Conduct of the election, and the irregularities therein. Any mere irregularity in conducting an election which does not deprive any voter of his franchise, or allow an illegal vote, or change the final result, will not vitiate the election. An election is not invalidated by the fact that illegal votes were included, when the number of such illegal votes is not enough to change the majority. But when the admission of an improper vote changes the result of an election, the election is void. The will of the majority is to be respected even though it be regularly expressed. 3. Sufficiency of the election. A majority of all the votes cast is not requisite to the choice of an officer, except when made so by express statutory enactment. Where there is no positive statute to the contrary, a plurality of the votes cast will suffice to elect. That the candidate who stood highest on the list in ineligible does not give the election to the next highest. In such a case there is no choice, and the election is invalid. The ballots cast at an election are better evidence than the tally list, made from them, of the number of votes. 4. Imperfect ballots. In an election for school directors, all tickets voted which have more names for the offices than there are vacancies to be filled must be rejected. A single piece of paper cast as a ballot and containing the name of a candidate more than once, should be counted as one vote, and not rejected as illegally thrown. If a voter has written upon his ballot the name of a particular person in connection with the title of office, and omits to strike out the name printed on it in connection with the same office, the writing will prevail over the printing, and evidence to the contrary is not admissible to explain it. A ballot endorsed for trustees of public schools, instead of for trustees of common schools, was held sufficient. So, where a statute provided for the election of police magistrates, votes thrown for police justices were held to be good. It seems that a mere defect in the naming of a candidate will not render the ballot illegal, if the intent of the voter can fairly be gathered from it, as where J. was a candidate for election in a district where there was no J. It was held that votes cast for J. were presumably intended for J. and should have been counted for him. If the sound is the same, errors of orthography will not authorize the rejection of the ballot. Technical nicety should not be allowed to prevail over the intention of the voter fairly gathered from the ballot and facts of general notoriety. Where one Joseph Torkington was a candidate for constable, it was held that votes cast for Torkington for that office should be counted for Joseph. But where the word Pence was written on a ticket for sheriff, and one Spence was a candidate, the vote was rejected. Where, in a ballot, a name placed above another by a slip partly obliterates it, it will be sufficient if it shows the intent.